is up, everybody? So yesterday, the state of Wisconsin Circuit Court in Sheboygan County finally ruled on Kathleen Zellner's latest filing on behalf of Stephen Avery, and the judge there denied the request. Now, I have the full 31-page filing here, and I'm going to go over it. I'm going to break it up into a couple of videos so you don't have to sit through one giant long video, but if you do want to watch it all together, just watch them back to back to back. But here we go. We're going to go over it here. It's on page number 1. It says the state of Wisconsin Circuit Court in Sheboygan County, State of Wisconsin versus Stephen Avery, case number 2005 CF381, defendant. The defendant is back before the Circuit Court with a post-conviction motion through his attorney Kathleen Zellner and associates. The defendant asserts that newly discovered witness statements will establish that there is a viable third-party suspect for this offense. The defendant asserts that evidence regarding this third-party suspect was never presented at the time of trial, and the failure of the presentation of the alternate suspect undermines the confidence in the jury verdict. The defendant further asserts that the state violated the provisions of Brady versus Maryland if the court rules that the third-party suspect evidence does not meet the requirements to grant relief to his request for post-conviction relief. The defendant asks that alternatively the court grant him a new trial in the interest of justice. The court, then it says facts. The court will not recount the full record in this voluminous case. The facts have been set forth in numerous filings in prior court proceedings. This court will only refer to the facts alleged in the current motion before the court. Prior to the commencement of his trial in 2006, the trial court entered an order requiring the defense to identify any individuals other than Brendan Dassey that it intended to suggest was a third party responsible for any crimes charged against the defendant. Furthermore, the court stated that the admissibility of evidence regarding a potential third-party suspect would be required to meet all standards set forth in the ruling in State versus Denny. The defendant provided notice that he would assert that there was a reasonable possibility that others committed the murder with which he was charged, including Scott Tadek, Andre Martinez, Robert Fabian, Charles and Earl Avery, and the Dassey brothers. In addition, the defendant argued that the ruling in Denny did not apply to his trial and that if it did, he should be permitted to present evidence regarding several alternative suspects. The trial court found that the standard set forth in Denny did apply to the defendant's evidentiary offering and noted that in the absence of motive, it could be more difficult to offer evidence that would be relevant and material to a third person having committed the crime. The court concluded that nothing in the defendant's offer went beyond the level of speculation. The court stated that while the defendant identified many people with the opportunity to commit the murder, no clear motive for the crime was identified for any of the alternate suspects, failing to meet the Denny standards. After the defendant was convicted of this murder, he filed a post-conviction motion. The court concluded that while the defendant may have supplied evidence as to motive to frame the defendant, none of the evidence identified a motive for Bobby Dassey to murder Teresa Halbach. Without establishing any evidence of motive, the court concluded that Mr. Dassey was precluded from being named as a potential suspect under Denny. The Wisconsin Supreme Court allowed the decision to stand. Several other post-conviction motions were filed, denied, and upheld by the appellate courts. The appellate court ruled on the defendant's last post-conviction motion on July 28, 2021, upholding the circuit court's decision. The court found the content of the defendant's motion was insufficient to entitle him to a hearing on his claims. While the motion was pending before the Court of Appeals, the defendant requested that the court stay its decision and remand the matter back to the circuit court for evaluation of a new claim. The Court of Appeals noted that the defendant was asserting a Brady violation involving the affidavit of a new witness, Thomas Sawinski. In his affidavit, Mr. Sawinski asserted that he saw Bobby Dassey in possession of the victim's vehicle several days after the murder. Mr. Sawinski stated that he called the Manitowoc County Sheriff's Department later that day to report what he saw and was dismissed by the deputy. In its decision of July 2021, the Court of Appeals stated that the defendant's newest claims regarding a Brady violation had little or no relation to the claims before the court in that appeal. The court stated that this issue should be resolved in a separate post-conviction before the circuit court. As of this ruling, the defendant brought this post-conviction motion. The defendant asserts that by failing to disclose the statement of Mr. Sawinski to the defendant, the state withheld exculpatory evidence from the defense in violation of the Brady rule. Furthermore, the defendant states that the evidence supplied by Mr. Sawinski creates a direct link between Bobby Dassey and the murder of the victim. As such, the defendant asserts that he was denied the opportunity to present evidence of a viable third-party suspect at his trial. By denying the defendant the opportunity to present that defense at his criminal trial, he argues that the issues in the case were not fully tried and that had the jury been presented with this testimony, the verdict in the case would likely have been different. The defendant is now asking the court to review the claims and grant relief, or in alternative, grant him a new trial in the interest of justice. For the affidavit of Mr. Sawinski to be admitted as evidence establishing Bobby Dassey as a viable third-party suspect in the murder of Teresa Halbach, the defendant must satisfy two separate tests. The Denny requires the defendant to show the third party had a legitimate tendency to commit the crime at issue. To meet this burden, the defendant must show that the third party had a motive to commit the crime, the opportunity to commit the crime, and that there is some evidence directly linking that party to the crime that is not remote in time, place, or circumstances. The defendant also raises and correctly identifies that the test set forth in State v. Edmonds also applies to the admissibility of the affidavit itself. The Edmonds court established a four-part test to determine if the evidence is newly discovered and admissible for consideration by the court. First, the evidence must have been discovered after the defendant's conviction. Second, the defendant must establish that he was not negligent in seeking out the evidence in question. Third, the defendant must establish that the evidence is material to an issue in the case. Fourth, and finally, the defendant must prove that the evidence offered is not merely cumulative to that already in the court record. The defendant further notes that only if these four requirements are met is the circuit court continued to determine whether a reasonable probability exists that a different result would reach in a new trial. In his affidavit, Mr. Sawinski states that in the early morning of November 5th, 2005, he was delivering newspapers to the Avery salvage yard in the course of his employment. Prior to actually delivering the newspapers, Mr. Sawinski states that he encountered Bobby Dassey and an older unidentified man pushing a dark blue RAV4 down Avery Road toward the junkyard. Mr. Sawinski stated that the car did not have its lights on. After delivering the newspapers to the Avery mailboxes, Mr. Sawinski states that he drove back towards the exit where Bobby and the older gentleman and the car still were. Mr. Sawinski states that Bobby then stepped in front of his vehicle in an attempt to stop him from leaving the property. He further states that the headlights were shining directly on Mr. Dassey at this point. Mr. Sawinski then states that he came within 5 feet of Bobby Dassey, who looked unhappy to see him on the road, and was forced to swerve into a ditch to avoid him. Fearing for his safety, Mr. Sawinski called out "Paperboy, gotta go," and drove toward the exit. After learning that Teresa Halbach's car was found on the property, Mr. Sawinski states that he realized the importance of what he had seen and immediately contacted the Manitowoc County Sheriff's Department to report the encounter. Mr. Sawinski then states that after viewing the television show Making a Murderer, he contacted the Innocent Project in New York to report the incident again. Finally, in 2020, Mr. Sawinski contacted the defendant's current counsel and the current affidavit was drafted. With respect to the first requirement of the Edmonds test, the defendant states that Mr. Sawinski did not come forward and contact the defendant's counsel until April 2021. In his corrected affidavit, Mr. Sawinski states he originally believed he contacted the defendant's counsel in 2016. However, it was later discovered that Mr. Sawinski actually sent his communication to the Innocent Project in New York. Counsel states that this information was not relayed to the current defense team at the time. The defendant asserts that in spite of numerous discovery requests filed by his original trial counsel, the record of the call that Mr. Sawinski made to the Manitowoc County Sheriff's Department was not turned over to them until after Mr. Sawinski came forward in 2021. An additional specific discovery request was made. For the purpose of this test only, the court will conclude that the evidence in the Sawinski affidavit was discovered by counsel after the defendant's conviction, satisfying the first requirement of the Edmonds test. The defendant next addressed the second standard of the Edmonds test. The defense asserts that it was not negligent in seeking out the evidence set forth in Mr. Sawinski's affidavit. Prior to Mr. Sawinski's contacting his attorneys in 2021, the defense states that it had no way of knowing that such an account of events existed. The log of the call that Mr. Sawinski made to the Manitowoc County Sheriff's Department was not turned over to trial counsel in spite of numerous discovery requests. Neither trial nor appellate court counsel was on notice that any such contact occurred. The record of the call was only delivered to current counsel after Mr. Sawinski contacted the team directly, and the team specifically requested records of any contacts between Mr. Sawinski and the Manitowoc County Sheriff's Department in order to verify the assertion made in the affidavit. Based on those facts, the defense has met the requirements and satisfied the second standard of the Edmonds test. The third standard of the test requires that the defendant establish that new evidence offered is material to an issue in the defense case. The evidence submitted as being material to the defendant's motion goes to this theory that a third person committed the crime for which the defendant was convicted of. For evidence to be admitted to establish that a third party committed a crime rather than the accused, the evidence must meet the test set forth in Denny. For evidence to meet the Denny test, the evidence must show that there is a legitimate tendency that a third party committed the crime alleged. More specifically, the evidence must establish that the third party had motive, the opportunity, and a direct connection to commission the crime itself. While the defendant does not have to prove the guilt of the third party at the level that would sustain a conviction, evidence that simply affords a possible ground of suspicion against the third party is not admissible. The defendant asserts that the evidence in the Sawinski affidavit establishes a direct link between Bobby Dassey and the murder of the victim. By linking Bobby Dassey directly to the vehicle driven by the victim, the defendant asserts additional evidence previously discounted in this case may be reconsidered by the court, further supporting his third-party suspect theory. The defendant argues that this previous excluded evidence includes a CD copy of the computer hard drive found in the Dassey home. The defendant argues that this CD, which contains searches of terms and subjects including images of violent pornography, which would establish a sexual motive for Bobby Dassey to have committed the murder. The defendant argues that the Sawinski affidavit also establishes that Bobby Dassey had the opportunity to not only commit the murder of Teresa Halbach, but also to plant evidence, including the defendant's blood and DNA in the victim's RAV4. Further, the defense argues that Mr. Dassey's possession of the RAV4 also provided him access to the key to the victim's car found in the defendant's home, as well as the victim's electronics found in the burn barrel along with the victim's remains. The defendant finally asserts that the information in the Sawinski affidavit could impeach the testimony that Bobby Dassey gave at trial, in which he stated that the victim never left the property and was last seen heading towards the defendant's trailer. With respect to the motive element of the Denny test, the defendant argues that the state clearly considered that sexual assault was a motive for the murder, as evidenced by seizure of the family computer in the Dassey home. The defendant asserts that evidence of Mr. Dassey's motive to commit the murder was contained on the hard drive of the computer that was copied onto a CD, referred to as the VELIE CD. The defendant cites that the decision of the Court of Appeals, in which the court stated the content of the CD may become relevant to the defendant's motion if the defendant could prove a direct connection between Mr. Dassey and the murder committed. The defendant goes into a lengthy argument as to how the evidence found on the Dassey computer establishes a motive for Mr. Dassey to have committed the murder of Teresa Halbach. The defendant asserts that searches for the words and images found on the Dassey computer shows an obsession with violence and killing. The defendant further states that images deleted from the computer were pornographic in nature and depicted violent images of the torture and mutilation of young females. The defendant then refers to the affidavit of Brad Dassey, the half-brother of Bobby, who states that he had a conversation with Barbara Dassey, Bobby's mother, in which she states she hired someone to delete the files from the computer in question. The defendant hired an expert to examine the Dassey family computer. His expert, Mr. Hunt, states that he discovered 8 periods of time close to the date of the murder from which the files were missing and presumably deleted. The defendant then states that Special Agent Thomas Fassbender examined the CD and in his report described media that he found on the disc images of the victim and the defendant with a date of April 18th, 2006. Images of nudity and both sexes included pornography depicting bondage and possible torture and pain. He further stated that other images on the CD included those of pornography, including acts between humans and animals, images of young women, and injured and mutilated people. Well, that's where I'm going to end part 1. I will be right back with part 2. So this is an extremely interesting read. Let me know what you think. Leave some comments below, and I will see you again real soon with part 2.